I think that it's quite a shame how many left liberals find the very idea of nullification so icky, when in fact they've been some of the most successful at it. We have all these sanctuary cities where city governments refuse to go along with federal immigration laws. That's nullification. We have, of course, the medical marijuana situation in California, where despite the Supreme Court saying you can't do that, the state of California says, yes, we can. That's nullification too. And of course, you know, the librarians who destroyed all those records rather than turn them over because of unconstitutional national security letters, that was also nullification. So it's funny how successful civil liberties and civil rights have been protected when the federal government's ignored. I think that some of this has to do with this idea that the central government actually protects our rights, in particular better than the state governments. Now, of course, I'm not a big fan of state governments, but they are smaller than the federal government, and they're much less murderous, as Scott pointed out. But the state governments sometimes do go a bit far, and I think one very important civil liberty to kind of think of this whole topic is one that I don't hear many people talk about on the question of decentralism or centralism, and that's habeas corpus. We've just seen both the Bush administration and the Obama administration do everything they can to counter the principles of habeas corpus, these principles that are as important as any principles of law and liberty devised in Western history. The principle that you can't just lock someone up and not even explain why. I mean, that's basically what it comes down to. It's a very profound part of our legal structure. And we've seen it attacked by the executive branch of the federal government. Of course, we've also seen it somewhat, at least seemingly protected by the federal courts, where the federal court says, well, you can't quite go that far, but you can go this far. And indeed, if you really look at those Supreme Court decisions during the Bush era, regarding Guantanamo in particular, we kind of see the Supreme Court saying, you can't do this without Congress. And then the executive comes in and says, we got Congress. The Supreme Court says, you can't quite go that far, you need a judge involved. And they say, well, we have judges, we created a tribunal system. And one thing that gets lost in all this is no one actually thinks about how habeas corpus was before, say, the mid-19th century. Everyone just assumes that, of course, habeas corpus, like everything else that federal courts do, is a function of the enumerated powers of the federal government, right? I mean, we don't want the federal government, and including the federal courts, to have too much power. We want them to be limited. That was, in fact, the whole idea of the enumerated powers doctrine, right, in the 10th Amendment. But on the other hand, we kind of like the idea of a judge being able to say, hey, wait, are you detaining that guy properly? Now, the interesting, this seems kind of a paradox, and actually, if you look at English history, in England, habeas corpus didn't come about because of a bunch of libertarians in 1215. That's actually quite a distortion. It came about because of a bunch of opportunistic judges wanted more power for themselves. And in fact, many of the first cases of them exercising this power had little to do with the person being detained. They just wanted the money. They just wanted the case to go through their court. They're like, wait, you can't do that, we do that. And if you look at the way habeas corpus got bigger and bigger in England, it wasn't quite as admirable as many people kind of make it out to be or assume it was. When Parliament finally adopted the Habeas Corpus Act, it was because the House of Commons was ordering the jailing of councils from the House of Lords. The thing that finally made them want to be able to protect their civil liberties, they didn't want to be jailed. Now, that sounds all well and good, but in America, it was different. People like to think, well, England brought us habeas corpus, the common law, the rule of law, the Magna Carta. This is largely bunk. I mean, the American people weren't big fans of English common law. They associated that with England. They had their own law, their own local law. But eventually they started to like aspects of common law because they liked the pro-liberty element. And so they started adopting things like habeas corpus on their own. In the early 18th century, Queen Anne proclaimed that Virginia had habeas corpus, but the colonies were already practicing it. And by the time of the American Revolution, the Americans already had it. And when the Americans fought their revolution, one of the big complaints they had about the central state was, hey, you guys say you're for freedom. You Englishmen say you invented liberty, basically. And, you know, there's some truth to it if you define liberty in terms of certain doctrines, right? I wouldn't say they invented liberty, of course, but, you know, in dialectically. They said, you Englishmen say that you're all for the Magna Carta, but you're taking away our habeas corpus, you're stripping it from Quebec. This was a major grievance. And so when the United States Constitution was born, who had the power of habeas corpus? Not the Supreme Court. We all did. Every courtroom in America had it on their own as part of American common law. And indeed, the Constitution says that, you know, they can't suspend habeas corpus except in rebellion and public safety and all that. And a lot of people say, yeah, there it is, right there in the Constitution. And they were horrified when Alberto Gonzales famously said, the Constitution doesn't protect habeas corpus, or it doesn't guarantee it, it just prohibits taking it away. And people said, that doesn't make sense. Well, of course it makes sense. Because like so many of our other rights, they didn't come from Washington, right? We had them. And it's only Washington that we wanted not to take them away. And what's really radical about all this is early in this republic, habeas corpus was one of the most powerful states' rights ever. In 1836, Massachusetts court freed someone from the Navy. And this wasn't considered odd. It was the federal government in America, not in England. It was the central state that was being checked from down below. Meanwhile, when habeas corpus got, you know, centralized, like in 1833, it was the first major time the Congress expanded federal habeas corpus. It was to protect their own. It was in response to the Tariff of Abominations, where in 1833, South Carolina said, we're going to start jailing people enforcing this tax. And the federal government said, no, we're going to issue writs of habeas corpus to take them out of your jails. So it took on the centralist character. And of course, during the Civil War, during the slavery issue, where all these states had personal liberty laws and used habeas corpus to free people, and we had Joshua Glover freed in Wisconsin on habeas corpus, and the guy who stood up for him, Sherman Booth, the abolitionist, he was jailed for basically being an abolitionist and encouraging this. And they issued a writ, the Wisconsin court, and the Supreme Court overturned it and said, no, the states don't have this power. 1859. That's the real death of American liberty. And then the Civil War, of course, Lincoln suspended it a dozen times almost with Congress. And after that, the federal government took this liberty from us and was supposedly our guardian. But you know, during Reconstruction, when they passed the Habeas Corpus Act in the 1860s, it was supposed to protect people from state governments. And it did to some extent. But you know, the first time they changed it, they went back on it. Habeas corpus was used to question the detention of someone who was jailed, named McCardle. And what was his crime? Criticizing Reconstruction. And from then on, the national government wasn't very good at making sure people weren't being detained unjustly. We had world wars with Japanese internment. We have the war on drugs. We have the largest prison population in the world, per capita and in absolute terms. Unless you count like the concentration camps, it's probably the biggest prison population ever. This is all spawned by federal policy. It certainly hasn't been reversed by federal policy. And this is what happened when the national government took over this powerful remedy. And it was a powerful remedy. So what's this all mean? What this all means is the conservatives who say, you know, the Guantanamo decisions were bad because the Supreme Court shouldn't be meddling, they have a very narrow point. But what they don't realize is under the original Constitution, it's not up to just the Supreme Court and the federal courts what the military does at Guantanamo. It's up to the state courts. Under the original Constitution, under the way things were, and I think under the way that they actually are, if you read the law and you understand this history, the federal government's detentions are the ones that should be checked the most, and they should be checked by local powers. I think that one thing that we often forget is that people do, sometimes when they seem to completely disagree, they might kind of agree more than they think they do, and more than we think they do. But I think it's important to instill a little bit of this cognitive dissonance here. The federal police state is not our savior, and the federal courts do a terrible job at protecting our rights. Look, even, let's say for the sake of argument that the federal courts do some good once in a while against state authority, just, you know, broken clock. Well, look at all these erosions of Miranda over the last few years, all these erosions of the Fourth Amendment. By nationalizing our rights, we've given the greatest monopoly power on earth, the U.S. empire, the last say, and it was never meant to be that way. In fact, it's antithetical to the good principles of the American Revolution. And so I think that it really is an important time for these ideas to be catching on, and we have to find kind of new and interesting ways to spread them. And of course, many of us are, and this is one reason there's so many people here. But I think that if we just frame the discussion a little bit and look at all of these forgotten legacies of decentralism, we can really push the humanitarian vision that political decentralism and smashing the central state really represent. Thank you very much.